Hey, everybody. We are back with Josh Schiffer, the man of the hour, to discuss the Karen Reed trial and defense tactics. I know a lot of people are probably glued to the trial right now, but, you know, hopefully they'll catch this on the lunch break and afterwards, which is totally cool. So, yeah, I love that Josh was on vacation and his posts once a day are like, oh my gosh, I can't believe what's happening.
Absolutely. So, guys, thanks so much for inviting me on again. I keep up here with both of y'all pretty religiously. You're some of my top follows because I just love the fact that you're not the salacious, pound the corp kind of people. And that's big to me.
Yeah,
I love it.
It's big to us.
Yeah. Yeah, I've done true crime now going on like 5 years. And when I started, I had no idea that true crime existed. Sure, I grew up during the OJ era, but I wasn't even a lawyer there. And then court TV is a thing, but it wasn't necessarily I lived it. It was every day. And I wasn't really into the whole pop culture angle of it. And then when I fell into it, I realized exactly how true crime has supplanted fiction in entertainment, which I really appreciate. And I think there's a lot of space out there to talk about how true crime has moved culturally into a far more prominent place. Typically, or really because of people like you and what y'all are doing. The threshold to entry for regular people who have an interest and a passion to get involved in true crime with technology is amazing. And y'all drive the conversation as much as the people at the networks and behind the scenes that we never hear about. That's great to me. It is a market of ideas. And I particularly appreciate, and I'll speak for some of my colleagues and friends, we don't want to go on the screamy, yelly, there are lawyers that do. And man, there are lawyers that advertise tastelessly on the back of buses and do all kinds of crap.
Well, that's true.
and ain't me. And what y'all do, and some of my other good friends in this universe have been stayed away from the trash and really concentrated on the legitimacy. And that may not get you as many clicks as you absolutely possibly could.
Right.
That's not what this is about.
No, we do it because we love it and hope that people appreciate some of it. And that's cool. It's slow but steady. It's all good.
And I thank you. And remember, this Karen Reed case, this YSL case, and it was Murdaugh. Before that, we had Johnny. There's always another really fascinating story, a really fascinating drama. All trials are a tale of betrayal. It's finding out where that betrayal is. And there will be no ones. And I hope that as true crime continues to grow, we continue to kind of segment out parts of that part of that media space where if you want to chase certain there's a great big spot over there, but some of the local regional fame may evaporate. Really, no one's going to care about Canton. Give it 6 months.
Exactly.
And all of these sudden celeb people that go out and grab something. Man, God bless them. Fantastic. I've met some amazing people getting involved in visiting and analyzing some of these cases.
Yeah.
Certainly some of them stick around, but unfortunately when some of these people that are really involved locally, when it's not there locally, they don't have any connection to what else is going on. Their connection fades and that community naturally dissipates. What I really love about y'all is your activity and engagement with the true crime community, because you're here for the long haul. And that really matters.
Yeah.
Thank you.
Thank you.
Thank you. Yeah, that's, Rachel and I have talked about that a lot, Josh. And, we really do want a platform and a show that is, open to people, open to everyone's thoughts and ideas, not slanted one way or the other. So I appreciate you saying that a lot, because that's exactly what we're striving for.
The respectability of discourse still matters for at least hopefully big chunks of America.
I know.
I know we're seeing stuff. I'm 47. We talk about how this media, it's changed so much. Any of these stories 20 years ago would have ended anybody's career. And now we just get this fire hose of information and people trying to manipulate it and manipulate the emotions of the readers and the listeners. Because when you're right there on a big cape, man, it's the most important thing in the universe. You can't see anything else when you open your eyes. But there is that rest of the universe and the respectable discussion among people that really care about this stuff, because it is our culture and it is our society, which is why everybody thinks Reed is nuts. So really, like, I'll rip that Band-Aid off right now.
Hey,
this
it is
fascinating.
That's why we're talking about it.
It's
exactly.
good.
That's why we're talking about it. And I think, it's still gripping. The most gripping thing to me is I'm at the point now where I can't really read tweets and what people are saying is happening in court. I have to watch it without commentary for myself, because I'm literally having to go back and be like, wait, I don't think that's what they said. And I'm like, no, that's not what they said. So I'm like, okay, people, everyone stop interpreting for me. I just need to go back and watch this with no comments, and then when I have questions about the legal stuff, I'll tune into some of the lawyer shows and stuff that explain these things. But I'm like, people are interpreting the same information so many different ways. Like, I can't, it's more than I've ever seen them. I mean, I'm a psychologist. Like, I see people interpret the same thing different all the time, but this is a whole other level of confirmation bias. It is a whole other, like, on both sides.
And isn't that illuminating from the, from our perspective as outside analysts that know about how the trials work and are thinking a lot about jurors? We out here are picking over and creating these ideas and opinions and doubling down on them or questioning them. All of that is because we think we know what jurors would think, because we think of ourselves naturally as, if I'm a juror, this is what. You ain't a juror. You don't know how little that jury sees, and you don't know what part of the day's testimony or the week's testimony or now the month's testimony is gonna stand out. And it reminds me in Arbery, which was the horrific murder down in South Georgia of Mr.
Ahmaud Arbery. It
was murdered by these vigilantes, and it was off during the trial. There was this moment, and everybody in true crime just narrowed it: the toenails. The toenails.
Yes.
Whether he was jogging or not, is he a runner, and is he alive? And man, for like 24, 40, every single true crime from minor to national was like, oh man, it's all about these toenails.
Yeah, I remember that.
Jury didn't care. People asked him, they're like, oh, talk about the what toenails? We weren't
right.
Toenails. So it's a great cautionary tale, like you're talking about, to really step back and think about, what did the jury really see? Because they're not hearing about the scandals on the outside and the allegations, and they're going to get just what they're picking up with their interior tele, all of their receptors.
Right. And at what part did they zone out? And then they have to rely on the other juror to tell them what happened during that time. And at what, it's like, I told Scott before we got on, I said, if I were a juror right now, it would be halfway through all of this testimony, and I'd be like, crap, I should have been writing down these times. Like,
and all about confused. How much of how the brain works. Like, information comes at everybody, but everybody doesn't receive that in the same way. I have pretty spicy ADHD, and man, I know when I'm paying attention, when I'm not, because it took 47 years to figure that. And it's wonderful now, because when I was a kid, they didn't tell kids that had ADHD how to work with it. Now adults, it really has become interesting, because it's not a disability, it's a different ability, but you just gotta work with it. Jurors have all those same issues. We talk a lot about recency, primacy, first versus last. What's the first thing you heard and what's the last thing you heard? There's very strong schools of thought talking about how information's encoded on the front part of your brain, because some people's brains are really awesome at hearing something and keeping it swimming around, and they're actively engaged with that idea, and it's helping them make decisions. That's
working memory. Memory.
Oh, see, this is why we got the expert, y'all. Other people, it takes a long time to encode, but when they finally do receive the information, it embeds almost deeper in them. But people receive that, and it's a whole spectrum. Have you ever met these jurors? I haven't. I'm using all of my worst biases when I look at jurors, because that's what jury selection is. It's an exercise in bias. Well, how do you think that person's going to vote? Well, what do I know about them? Almost nothing. So let's make some big, broad, sweeping generalizations.
Right. Well, right. I mean, yeah, you got to ask these people all these questions beforehand to pick them, right? But you really don't know the nuances of I mean, you can get broad spectrum. Who are these people? But all the nuances and how they think, I mean, unless you're going to have everyone undergo some really detailed neuropsych stuff. And even then, I mean, it can be a crapshoot. So
it's an art as much as a science, because the psychological tools needed to do those assessments, they have come miles and leaps and bounds. None of it's perfect. No medicine is perfect like that. That's just not the way medicine works or healthcare works. And even then, with our biases and with our selection criteria and things like that, you don't know what's really going to land with that juror. That one little thing can set a juror up. We talk about you're always on when you're in court in front of the jury. That eye roll at the wrong time for Karen Reed is something she needs to think about. Because guess what? She's got, you can call it resting B face. You do all kinds of, she does not have this bubbly,
not at all.
And she's not a blank slate.
No. And that's not a bad thing at all. I was married to a former financial analyst. There are a lot of people in that industry like that, because that's the kind of people you get in that industry.
Yeah.
Sure. Yeah. Makes sense.
Yeah.
And really, I see some people would see a face like that, and immediately we see it all over the social. Oh, Ice Queen, she's that's the exact kind of one. Wow, why don't you lean into your misogyny right there, buddy? Like, you're making judgments about this lady before she's opened her mouth. That's on you. That's your fault. You're the one projecting exactly how incompetent you are because you don't know. Right. And when people make these big judgments, oh, she's a killer. She's a killer. There's no way. Da-da-da. Man, that's a safety response from the brain of the person expressing that.
Some visual diagnostics there.
There you go. Exactly, Rachel.
Yeah.
Absolutely.
So one of the things, though, I think when you're talking about like how to keep the jury, for all we know, like, are they engaged? Are they disengaged? One of the things, if we're talking about the defense, right off the bat from opening statements, I can tell you during the prosecution opening statements, I was like I was just like, check it. As soon as the defense got up there, I was like, what? They're loud. They're commanding
and started off.
Yep. They make sense. It's attention grabbing what they're saying. And yes, there's some dramatics in there, but it's keeping the attention. And I think
that goes to the storytelling, because one of my mentors, Jerry Spence, who you can look up Jerry Spence, and everybody in the world will tell you he's the most charismatic, listenable lawyer that's ever walked it. Like, he walk into a room of 1,000 people, everybody will immediately fall silent and stare at Jerry. He is freakishly magic. I've spent a lot of time with him and other people in his organizations personally. When he teaches storytelling and story development, one of the tools he uses is a classic movie. Have you ever seen Tombstone with Val Kilmer?
I have not seen that movie.
It's the story of the OK Corral done as like a 90s big Western. Okay. And it's got this storytelling that illustrates really strong connection with audiences. And Jerry, we watch the movie in the big barn with Jerry, and he provides commentary throughout it. And one of the things he talks about is, how do you engage people with stories? And the defense did it perfectly. The first thing out of the defense, having sat through voir dire, having sat through Adam Lawley's not highly engaging opening, which I kind of believe had a purpose. In fact, I'm going to give Mr. Lawley a lot more credit than others. The defense got up and said, Karen Reed was framed. Boom. Like, you ripped everybody's brain wide open. Yep. If you weren't paying attention to that moment, you weren't in that courtroom.
Yeah, agreed.
It's the reset button for that jury brain, collectively and individually, because everybody had to pop. And that's the encoding and the embedding in the brain. It doesn't matter what you said immediately after that, because the shock of Karen Reed is framed.
Yes.
Yep.
That was pretty powerful.
Through the boulder in the pond. And that's what everybody remembers. That's the anchor that then the defense has gone back and back and back with, in inflating and building a huge, not just alibi, but really a conspiracy theory that, in my opinion, has successfully shifted the burden back to the Commonwealth in a way that the Commonwealth continues to struggle with, and has, as I'm looking, a day or two and a couple witnesses left before we're going to hear a big motion for a directed verdict from the defense in front of the judge.
Yep.
And the jury makes its own mental mile marker notes. State's case is done. How do we feel about it? Because sufficiency of the evidence is going to be a primary theme for the defense due to the investigation issues, the evidence issues, the connections between all these witnesses issues. You got to take out all this garbage on the outside. They don't know about that. They only know about the garbage that's going on in front of that court in a tiny courtroom.
Yep. They're not on social media. They can't discuss it among themselves. Exactly. Yeah.
Right. What do you think, Josh, about the directed verdict? They always ask, right? But what do you think in this case? What do you think is going to happen?
It's rare. We have them. Every state has them. And for people that are unaware, in the criminal justice system and in the civil justice system, there are specific burdens that people have to carry or that parties have to carry. In the Commonwealth or the state, in almost all criminal case or all criminal cases, has this burden to prove a case beyond a reasonable doubt. More important, or as importantly, they have a burden to show that there's enough prima facie evidence, which is plain and clear evidence, to send the case to a jury. Is there enough there for a jury to latch into that connects enough with the accusatory document, that being an indictment, for the jury to really work off of? And it's one of the times where the judge gets to put their stamp on the actual evidence in the case. So far, judge has basically played traffic cop. That comes in, that goes out. You heard that, ignore it. You heard that, consider it, which, as we've all seen, those speaking objections and remedial instructions are worthless. Once you say the question, it's out there. That trickery and artistry of cross-exams. And that's why, yes, lawyers ask questions they know are going to be objected to, and they're going every single day. It is not boo-hoo, I got objected to. No. Yes, that stuff all the time. And the jury eventually picks up on that this is a defense attorney testifying when they object, because that's really what you're doing. You're testifying when you get up and say, they can't say that. Same with the state. State's going to try to testify. This is a case where I believe the defense is going to put up more than the average. Judge, at this point, it's midway through the trial. We don't believe the state's presented enough evidence to send it to a jury because all we heard from was the video and the officer and the detective and the victim. And 99.9% of the time goes, well, I absolutely understand that, but the case has been presented by the state. We're going to send this to the, and that's the way it should be. In most trials, the state better have that evidence. Yeah. This is different because of that burden shifting. And that burden shifting where the defense has built a conspiracy theory so directly attacking the witnesses, the accusers, and the Commonwealth. Basically saying that the Commonwealth's thumb is on the scale, and they've got a bunch of gangsters, hoodlums that are manipulating this jury to wrongfully convict us. That's a big difference than 99.9% of cases. Judge, I don't believe, is going to directed verdict it, but she is going to get a ruling out that will be reviewed by an appellate court, and that concerns her. This is not a slapdash. They just did it. Let's go on. No, there's some pretty good arguments that the defense is going to be able to make. I expect it to be in writing, and no more than a 10 or 15% chance of it actually happening at most.
Do you think she'll reserve judgment? Do you think this will be a delay?
Nope. No. I think that she will. There may be a 24-hour, let me put it down in writing.
Okay.
But I believe that the judge's mind has been made up, because during the presentation of the evidence in the first half of the case, the judge is doing their own check. But all right, they've established venue. This is where it happened. We got the right venue. Right. Are the parties the right parties? All right. Well, that's them and that's them. And did the police get up and elocute a crime through witness testimony that basically matches the indictment? Well, we've all seen the indictment. We know what happens. John's certainly dead. She was certainly driving something during the night. So there's enough consideration there to allow the jury or to require a jury to pursue their duties. Jurors are the finders of fact. And most people don't go back to the idea that the reason we have jurors is because otherwise smart, capable people can't agree. And when we can't agree, we need an independent trier of fact to tell us what the facts are and then apply the law. And those finders of fact, that role, that's something I don't think the judge is going to minimize. And I believe she's going to let the jury hear all of the evidence from both sides.
So that gets interesting to me when it comes to the experts testifying, because the judge is the gatekeeper of what is presented and where they're allowed to go with their questioning. My reaction yesterday to the voir dire of the 3 potential witnesses was that, of course, again, there are very different interpretations of what the dog bite lady, I can't think of what her name is.
Oh, what an interesting one that was.
But very different interpretations. And my thought was, let the jury weigh that evidence. Let the jury decide. Is she qualified? Is she not? Is she, I know you
sound like a judge there.
Come
on, Doc.
But is she qualified? Is she not? Is this evidence mean something or not? Just like they did with the cops. I didn't understand. I did understand the lateness issue, but I didn't understand what the big deal is about. Is she qualified or not? Is she this, that, or the other? Let the jury decide if she is. That's what you've done with everybody else. Why?
Exactly. And memorize the phrase that goes to weight, not admissibility, because it's a 2-part. If you've got evidence, be it physical evidence, written evidence, or testimonial evidence, the first question is it admissible? And that's a rule. It doesn't matter what the content is necessarily. Is it presented in a format that is admissible or not? Does it have a hearsay issue? Can it be in front of the jury? That's a big analysis, and that's the argument when you're trying to get something excluded or suppressed or unallowed. The second part of the analysis is weight and sufficiency. Now that you've got the statement, it's 100% up to the jury how to weigh and balance that. It's the power of the juror. You as a juror can hear the most wonderful sounding expert in the world, and they can go over their CV and their accent and all this stuff. You are absolutely instructed and required by the court to weigh that testimony individually. If you don't like it, if you don't think it's right, if you think that the person is a paid hack, if you think the person is a legitimate testifier, 100% you. And you're allowed to very explicitly ignore or minimize the impact of evidence personally. There are some kind of interesting rules, and different states treat little bits of it the same, about uncontradicted, non-corroborated evidence where there's a conflict, because lots of times as a trier of fact, you're going to hear evidence that from different perspectives might mean different things. And the judge is going to say, hey, that's why you're here. You're here because I can't be trusted because I'm just a judge. Those lawyers, they each have biases and loyalties. We need you people to hear from us on these conflicts, and then you are instructed to use your common sense, experience, eyes, ears. You get to decide what part of that is true. And when you hear 2 contradictory statements, the jury decides which one to believe.
Right.
Exactly.
So it's going to be interesting. If I'm a juror, I'm kind of put off by the way she entered that case. I'm certainly not going to trust her as much as I would trust some future experts. You hear
future experts.
I'd trust her more. Experts.
I'd trust her more than previous experts.
Yeah, and that's exactly it. And we're going to have future experts,
right?
And unfortunately, being a capitalist democracy, I can pay people to say a lot of things, and I try very hard, as all lawyers should, to be an honest and straight dealer. But there's a benefit towards putting out experts with the intent of that contradiction, or to introduce things that you may not believe but should be considered by a jury. And you don't have to have, especially as a defense, all of your experts lining up. In a civil case, the plaintiff really wants 12 people to get together, sing Kumbaya, and award a bunch of money. There's certain ways to disrupt that. In a criminal case, the state or commonwealth wants 12 people to get together, sing Kumbaya about here's the law and here's how it got violated, and they did it. The defense, I don't care if the jurors have different conclusions about the trial, as long as they're different. I don't want everybody to cooperate and Kumbaya. I want that super one direction, left or right person to take a firm, line. Nope, absolutely not. I'm not going to believe that. And then I want the next person to be totally offended by that. Because I want them to go in the back and kind of get into a fight. If they all go back and like, hey, we all agree on what we just saw, and it's the law, right? That's how we get our verdicts.
Yeah, exactly, 100%.
And this is why I work in family court, so that because I don't care what mom or dad thinks or who's paying me.
God bless you. Family court and family litigate. Georgia is one of these states where you can literally have a jury decide your divorce. Now, you want to talk about
thank you.
Reality testing, best alternative to a negotiated agreement. 12 idiots who couldn't get out of jury duty decide your children's.
I don't think so.
No. I'm never trusting. Never.
No.
You want to go let that happen? That's all on you. But that's why you have settlements. And that's why the settlements are so awful, because the best alternative to a negotiated agreement is 12 bodies in a box. And let's go talk about what you said, he said, she said, they said. And then, because it's family law, if there's a kid, hopefully there's an independent psychologist, guardian ad litem, somebody out there that's going to go talk for the kids, because jurors will always protect kids. Always. Kids are always innocent. And if you polarize cases or develop themes using minors and children and other dependents as fulcrum points, it's super powerful. But if you bone it, you're done. If the jury figures that you're trying to manipulate or use a kid in a way that could harm the child, dude, you're
bye.
You're hooked.
100%.
You just lost. And in family law, they will assign fees. Thank the Lord we don't get that in criminal. We are never subject to, you put up a crappy argument. By the way, that cost $100,000. Oh
man.
Which regularly happens in family. Half the battle in family.
They don't do that here, but
half of our divorce law litigation is arguing over who paid each other's attorney's fees, because the lawyers look at it as, hey, I got free reign to go mine this file, and as long as I win, I'm going to get fees from the other party.
Wow.
Not quite that easy.
Yeah.
So what do you think is the best thing that the defense is doing now? What is the worst thing that they're doing now? What are their strengths and weaknesses here in this case?
If I'm going to say weaknesses of the defense, of which there are several, the aggressiveness can leave a really bad taste in people's mouth. But they're not trying to get 12. Yannetti and Jackson can afford to lose a couple jurors. And there are definitely going to be a couple of jurors with their presentation that are going to be very pro-Commonwealth, because it's been an aggressive defense. They have called every one of these people liars, cheats, crook. That is a polarizing position. And that's generally a benefit for the defense, because it prevents 12 people from getting together and making an agreement. But it is uncomfortable. It can get really ugly, and you can lose that. And if you piss off all 12 of them, then they're all going to vote for the Commonwealth, and your client's cooked because
that's right.
And they've got to be careful overselling it. That explains, since Lolly's not an idiot. People stop calling him an idiot. This is an accomplished lawyer who has practiced serious criminal law for years. He is not a schmuck. He is not an idiot or a dolt. He doesn't have the case he wants, but no DA has it. He probably is more pissed off than anybody else about how crappy his cops were and how bad his evidence is.
The investigation.
This is just a giant dumpster fire, because he wants really good investigations with clear evidence and great cops that stand up and testify to exactly what happened and can't be ripped apart because they're dumb enough to text and say some of the things these chuckleheads have done.
Right.
And that's why Lolly didn't come out guns a-blazing.
Right.
Imagine if he did.
Oh, man. No, it's been kind of a slow burn, Josh, along the way. It really has, you know, and I agree with you 100%. He did not inherit a good case with the investigation and the sloppiness and, oh my gosh, all the things that Proctor's, just everything.
And don't be surprised, I know I won't be, when at the end, rather than taking the traditional state power, we do everything right, we're the light and the shining tower, it's going to be almost a request for help. The Commonwealth needs your help, and it's qualifying those jurors want to fix things. People in court want to fix things, and there's a very good opportunity for Mr. Lolly to get up and acknowledge the struggles of the state's case. Don't make excuses. These are civil servants, and this is a civil servant's.
Yeah.
That's something that is out of nowhere. And if I'm going to play Lolly, I'm sorry we don't have the kind of evidence that would make this easy. We don't. This is a hard set of facts because the best witnesses, the people that were there, you heard from each of them. They tried to tell you what happened from their perspective, but this case was slathered in alcohol. And this case was slathered in personal conflicts. And that caused the Commonwealth to struggle and gave the defense, as you've heard, a lot of opportunities to call into question the truth and veracity of the witnesses to this murder. And while no one was there to see the moment of death,
right?
Every one of them testified that he didn't come into the house. Every one of them testified the facts necessary to support this wild conspiracy theory the defense has linked themselves to and have told you is the truth. Every single one of those witnesses was consistent in telling you that they didn't see him die, but this is what they saw, and that's how he ended up there, and it makes sense. There's not another explanation that makes any sense.
Right.
And that's why we're going to ask you to convict Karen Reed of murder and beyond a reasonable doubt. He can engender that if the defense continues to be so aggressive, because the mistake the defense made was hitching their wagon to this conspiracy theory so aggressively. The criticism myself and other defense lawyers have levied relates to the defense building themselves a boat and having to sail it. You don't have to do that. You can send out 10 boats. You can send out 100 boats.
Yeah.
In this case, the defense has built this boat of conspiracy theory that if the jury goes, hold on, instead of beyond a reasonable doubt and everything that could possibly happen in the entire world, we've got beyond a reasonable doubt, and this is the other very specific thing that happened that goes against beyond a reasonable. Wow. Different choice there, because
but they don't have to choose one or the other. They don't have to, right? I mean,
guilty, not guilty.
They have to choose that, but they don't have to believe either side, which leads to reasonable doubt.
And that's generally what the defense does. Is the defense likes to suggest alternatives, and I have done that with stronger alternatives that I think what really happened. But I don't know what happened. It's not my burden to prove what happened beyond a reasonable doubt. My job is to show that other things could have happened.
Right.
Other things could have happened.
Right.
That's not beyond a reasonable doubt. And that's why by eliminating all these other things, basically, the defense has tied themselves to their own burden to carry. And I think it's great, but I think that they could have loosened the collar a little bit. Given those jurors some other choices, because the worry is a juror goes, I have to choose between these two versions. And that's not true. Like Dr. Rachel said, the jury can choose that it is not beyond a reasonable doubt, and they can have their own secret, mystical, illogical, whatever reason they want. They're a
so why do you
Exactly.
why do you think they locked into this boat then? What do you think that was about? Other
they
than really believing that was the case. I mean,
yeah. So absent all of the outside circus and incredible notoriety, if this was Joe and Jane and it was a neighborhood and a whatever, without that, it's a different case to defend. The outside influence, the notoriety has made it very likely that the jurors do know something about this case, that that's such a higher likelihood that there's some knowledge, there's people communicating. I don't trust jurors when they say they don't read the news.
Yeah, I don't either.
Right. Yeah. Same here.
It's a nice line, but come on now.
We
know that was not the manufacturer's recommended price. It was built to be on sale.
Yeah.
No one was paying for it. So that's gonna be. It really is tough to say where we're gonna end up, given the jury has, my opinion, plenty of information to convict. It's not the best though.
No.
And the defense is going to get up and run their defense. What we're really all waiting for are these MEs.
I know.
Medical examiners, in my opinion, are some of the most valued. They're independent more than the rest of they're not cops, man. These are techs. I get dead bodies, run tests on them, do a report. You're not going to be able to infer the stuff like we've heard from Proctor or these families about there being some sort of other motivation, secret stuff that no one knows about, but we're just going to suspect it's there. No, the MEs are going to come out and lay out their conclusions.
Yeah.
Right.
How that happens, man, defense could win the entire case with the right answer.
They could. Yeah. And it only takes one person, as we all know, Josh. I mean, yeah, and they are going to have their own expert. There's no question about it. I've said all along, this is going to come down to a battle of experts, in my opinion. And a lot of it's going to come down to the MEs.
And we've all seen these accident reconstruction videos and different arguments about there's no way she could accelerate to that speed, and there's no way that the plastic could do. We all have our life experience, which is valuable to be a juror, but these are going to be the experts. And when one of them testify, I just speculating. I imagine one of them is going to have a very firm cause of death belief with sufficient testimonial backing. They're going to say, here's where a blunt impact occurred. Here's how the scratches formed. Recently, in the last 48 hours, everybody's going nuts about those were raccoon scratches or vermin scratches. Because, man, there's lots of crazy stuff that happens out in the burbs. And this is Massachusetts. There's all kinds of wildlife out there, and there's a big wooded area right nearby. Yep. State or Commonwealth needs to kind of get in front of that. Defense certainly needs to deal with that kind of allegation, because that kind of good, kind of bad. The MEs really need to explain the physical injuries. I know there's going to be a lot of discussion about the eye bruising, and eye bruising does happen post-mortem. And you don't need a contact to your eye or with your eyes and face to get lots of bruising and discoloration. You've got some cultural issues. I have experience dealing with bruising and edema in different colors of skin. That becomes a very delicate and challenging discussion. You don't want to offend people,
right?
Especially if you're an ME. And the ME's report is one thing, the ME's testimony is another. You can write a very generic report and then testify in far more detail. And if you get the right ME, some MEs super dry. That might be exactly what the Commonwealth needs. Some MEs, we're going to have a little bit more color and engagement, and we see characters that we're not expecting in each one of these trials that are their own drama. In YSL last week, we had the court reporter and her converses.
Oh my gosh!
With Mr. Copeland, the super witness there, but that suddenly became a big deal, and know the jurors saw because they were literally talking about shoes on the record.
Right. Wow.
and you don't know what kind of character these MEs are going to be. But they've got to bring the receipts for the Commonwealth. They better have a damn clear. And here's what happened, and here's what happened, and here's what happened. That's why he's dead. And the scratches came from this, that, or the other. The speculation on this polycarbonate lens, kind of tired of it. I really want to hear from the experts.
Yeah.
I know. Like, can we just like get, me too. I'm kind of over it. How many weeks in are we? Can we get to the actual people that know what they're talking about?
Well, and right? You got everybody, but that's again why we love it, because guess what? I've changed headlights. I've changed headlights a couple of times. Yep. They're heavy. They're big. I've dropped a head. I'm sure I've dropped it. It didn't break. How hard you got to be hit running to? That's a really good question.
Right.
I know it is. Yeah.
And that's going to get into how do you back up at 24 miles? What is it, 26 miles?
24 miles an hour. Yeah. Yep.
Good stuff. It's like in a DUI trial. The state never. So you're always going to go through the field sobriety value. Touch the nose, the horizontal face, and the stag. The state loves those tests because there's tons of documents behind them, and they've been used for years and years, and everybody knows about them. And you trust that. Mm-hmm. The defense wants nothing more than for every field sobriety evaluation to be practiced by the jury back in the jury room. Exactly. There's nothing better than having a 50-year-old out of shape juror who's been sitting there for a day get up and try to do a one-leg.
Yeah, good point.
That's how you win the damn case, because if the state has said, oh, you can see on the video that he's weaving back and forth, and that's a clue of intoxication. You get 4 jurors back there, each of whom is stone cold sober at 2:00 in the afternoon, none of whom can stand on one leg with the other leg out less than 10 inches and it eviscerates the state and the cops at that point, because the cops are trained. Oh no, testify. These tests work. You're trained on this. You be confident.
Right. Yep. Nope. There's that doubt again, Josh. Yeah, 100%. Yeah.
Then you really got to work with those facts. If the Commonwealth digs in on some of this theory, I've yet to be convinced in any way that a body polycarbonate impact would shatter it the way that it was shattered. Right. Then of course there's the physical evidence, how they found it, where they found it, when they found it. That ties on. And you're talking about how would a hit to the body cause these. Lots there.
Yeah, there is.
Trying to figure out where the body would have ended up when you don't have precise measurements to begin with. And, I'm glad I'm not on this jury. Let's put it that way. Oh, man. It's going to be a long deliberation, don't you think? I think this is going to be a long deliberation.
So when you've got really contested cases that have, I'm just going to call it wacky evidence. Long is very common. Equally common is the nope, we're out. If this case jumped the shark, which is what I'm thinking in a case like YSL, which kind of happened with the Trump case in New York last month. We got a verdict fast.
Yes,
they did not sit and
they're sick of it.
They're sick of it.
Yeah.
And respecting that juror is part of the game. I've tried cases, especially short ones, where you start off by getting going, all right, ladies and gentlemen, I'm going to try to make this as respectful of your time as possible. This case is based off the word of one person. It just happens to be a police officer, and I want you to listen to them and read and everything's going to be, please, because then you're going to hear from my witnesses, and I'm going to ask you to do the same thing and listen then. But I don't want to waste any of your time, so let's just get to the evidence right now. This is a case about that, and sit down. Because since I'm not trying to win all 12, I just won a couple points for those jurors who are like, oh, thank God it's not one of these long court's boring. I know we're talking court lovers. Go sit through voir dire.
Just ask my husband. He comes in and I have a trial on. He's like, oh my gosh, how can you stand listening to this? Like,
yeah,
I love it.
Jury instructions. Slay me. I did a bunch of interviews about the Trump jury instructions because, when are they going to get them? I'm like, all right, have you ever gone and gotten a lecture from a Yeah. And after like 2 minutes, how are you doing with the retention? Now, imagine a judge reading you the most intentionally dry manual, because it's a manual.
Yeah.
Yeah.
It just happens to be printed as motions and forms and filing. Mm-hmm. They're going to read you a manual of the rules of court. Be sure you pay attention to everything.
Yep.
And these are a bunch of words, some of which you're unfamiliar with. The concepts may be foreign to you. You may never heard or understood some of these concepts. And we're not going to give you a copy of it, so you really got to remember it.
Yeah. Exactly.
At least in some courts, they do something called publish the jury instruction. But want to know who doesn't like publishing the jury instructions? Every plaintiff or police or state. Because when you publish the jury instructions, the jurors get to go back and hang on that difficult word. And that leads to division more than cohesion.
That makes a lot of sense.
And
yeah.
It's very easy for someone to go, no, man, that doesn't say that. It says this. And clearly that never happened. But jurors are bored off their asses by the time it gets, and you could have a very fast jury, because when they go back and go, nope, totally proved everything. We ready? You guilty? All right, let's do the paperwork. Same.
Wow. Yeah.
And it comes down to the actual personality of the jury, because
you could have that one detail-oriented person that says, no, I want to be sure. Let's lay out the timeline. Here's all the things I wrote. Yeah.
Who are the different personalities that exist in juries that we talk about all the time? We all, better lawyers, focus group and role play this extensively, because what we know is that we don't know all the perspectives, so you've got to explore it. So we reverse roles with characters. I do some training where literally I can tell you about the juror my friend plays, because they've been playing that same juror for 10 or 12 years, 15 years. And they're people that are based off of our lives that we really know. And then by role playing that and really enrobing yourself in the character, you give value to the lawyer analyzing whatever the argument is or the cross-examination.
How can I get that job? I want to be I want to be a pretend juror.
Go study more psychodrama. Go get your TAP and all that stuff. There's a little universe of the higher end lawyers. That's all we do. Like people.
How do I get hooked up with that job, Josh? We need to talk later.
We absolutely. It's a small world when you get to really the high end of litigation. It's something I've learned in my career. Remember, I started off as a public defender. I wrote books. I come from a smart family, but I worked my way up. You don't even know about those resources until you get to certain levels of lawyering, because they're outrageously expensive. But when you get to that level, some of the things you can do with your cases with enough time and effort and colleagues, mind-blowing. We regularly have psychologists that come in and we do focus groups. Focus groups are a huge, it's your playground. It's your sandbox. Hey, we tried to ask for this way. Let's tweak it a little bit and go in front of 10 people. And
hook me up with somebody who needs a fake juror.
Anytime you want, you can.
I'm ready to quit my job and be a professional fake juror.
Believe it or not, there's a whole world of jury assistance, assessment, evaluation, and here's the thing, there are lots of different theories as to it, because not all juries are selected the same way, presented the same way. The federal juries. I ain't no voir dire.
Yeah.
Federal jury. I was just talking with another friend of yours and mine, Franz Borchardt, who does a lot of federal work. He gets to submit some questions to his judge. If his judge wants to ask them, the judge will. That's voir dire. It's 30 minutes. Yeah. And people are, oh, no, that's not jury of my peers. Yeah, it is. That's the federal jury of your peers. And you get what they're going to give you. And no, you're not going to get to strike every. No, you're going to get a jury, and that judge is going to give it to you. So you get into the minds of the jurors. Every jury role play has some certain roles that we can kind of count on depending on where the case is, because they're such strong archetypes. And while these are broad brush and built completely on my own biases, my own perspective. They're very real characters. In my neck of the woods, we've got the county I live in, Fulton County, is big and long, and it has the city of Atlanta in the middle and rural people on both ends. The rural people in North Fulton County are traditionally more white, conservative, educated, but not all. And that population changes. And guess what? You can look at one old white dude and say, oh, he's from North Fulton. Oh, he's a Southern Baptist who's conservative and feels like, well, that guy moved here from New York 2 years ago. And he was never in a Baptist church. He has no idea. And when you start talking religion, he thinks so. You can come up with the archetypes of, all right, this stereotypical African American female single parent teacher, because you get this very general stuff. But then you use those perspectives to build roles and reality test your arguments. Your argument lands differently depending on who the person is. Right. I may be that kind of juror who gets up, walks into the jury room at the conclusion, takes charge, needs to be the guy in charge. I may be the person who's checked out. I was like, God, I can't believe I'm here. What's the fastest way out of here? There's jurors who are like, this is the biggest waste of my life. There are jurors who this is the greatest moment.
Sure.
Yeah.
Sure.
That's why you need to watch the show Jury Duty. Josh, can't believe you have to watch it.
My only problem with fiction these days is that real life is so much better. It's a
reality show.
True.
It's a reality.
What we are seeing currently in our just general national discussion of law, crime, politics. Glad that my grandparents aren't. They wouldn't even know how to handle this. The idea that some of these inconsistencies have poked up, it's wild. But at the same time, I'm thrilled that so many more people now know about what's going on in criminal courts than ever before.
It's important. I think it's important.
I think that we get a change to the felony murder rule in the next 20 years because of additional coverage. Because felony murder rule, for those who aren't familiar with it, is basically every state rule that if you're doing something that ends up being a felony, doesn't matter what, literally doesn't matter what, and someone dies unintentionally, what doesn't matter. Right. Everybody involved in those crimes can be convicted of felony murder. And that happens. It's the extension of the conspiracy theories. When you hear about the kid that was just in the back seat of the car, when the car gets blue lit and the guy drives crazy and kills somebody, but the kid was literally in the back of the car screaming the entire time, please, please, please let me out. Please, please, please. They can sentence that kid to life without parole.
Wow.
And when you hear of there's always bad senses, whatever. When you hear the ones that shock the conscience, it's very often felony murder. Yeah. It's the most powerful tool prosecutors have because they go to everybody that was ever involved and go, hey, if you don't want to plead guilty or plead and cooperate, we got like 4 more other people. One of them is. They're the one that we're going to dismiss the felony murder. Everybody else takes it.
Jeez.
It's a tough to go. Well, and here's the other one. Hey, there's you and your brother both in the back seat of the car as his friend's the one that picked you up and is driving. You don't rat on your brother, you both go down forever.
Yeah.
Wow.
There's a death penalty case, the Nebraska 6 or 9, whatever it was called. They did that with the death penalty. Wow. And they said, if you don't confirm these statements that we've pre-written for you and have decided that is the truth, we're going to give the needle to your friends.
Wow.
Would you lie to save your friends? Yes, I'd lie to save my friends. Would you lie in court to save your friends? Man, at that point, my friend's getting killed by the state. Yeah, I'm pretty cool with lying. Stop. Go to prison forever or lie? Well, how am I not going to prison forever? Oh, I mean, if I lie, you won't kill me, and I get out a little bit earlier? Oh. Let's have this discussion. And then, of course, when the defense attorney turns around and says, we need the terms of the deal. The motion in Georgia is called the reveal the deal motion. where if anybody has received any substantive assistance from the state in return for any kind of cooperation, you have a right to reveal the deal. You should at least know what they're doing if they're going to do it. And the state fights us on it every single time because they don't want the jury to know the state bribes people to lie.
Right.
And now you get into the mind of that jury. How would you feel knowing that, man, this really makes a whole bunch of sense? The facts kind of line up. Man, there's maybe not a picture, but yeah, that guy did that thing. Mm-hmm. And then you hear the witness who says, absolutely, all that happened 100%. In fact, I was there. I was involved. And yep, this is the truth. Oh, except, yeah, I don't have to go to prison or that's why that matters, because I don't care how certain you are as a juror. You better be suspicious and cynical of someone who is appearing while being compensated.
Yes.
Right.
Not cash in the rest of their life. Yeah, I'm compensated by not dying in prison. And that's the Copeland issue from last week in YSL. Copeland goes and testifies to what he talked about to state. He gonna get killed. So they gave him immunity and they gave him all this. He was still like, I ain't talking.
Yep.
But you already said this. Yeah, and if you want, I'll go say that again, but I'm lying. So then they are sitting in the back with a judge, everybody sworn, and a court reporter, ex parte. Insanity. Just
I don't.
Pin shows on that. Like the post YSL universe is just amazing. And literally tells the judge to his face, yeah, I'm going to lie about that. I'm absolutely going to lie about it. Meanwhile, the state is threatening to prosecute him if he doesn't testify to what he says is lies in open court. Is that the state suborning perjury? Well, I'd say yes. They know he's lying. Why? Well, he told them he's going to lie. While under oath in front of a judge on the record, he said, I'm going to lie. Right.
Mm-hmm.
I just love the picture of him floating in his pool with his shoes on.
That guy needs a talent agent. That guy is missing. He needs to, and certainly not Nathan Wade's, because we didn't even talk about, holy crap, that is insane. I've never heard the viciousness in my private texts and conversations with other Metro Atlanta lawyers that have been reserved for Mr. Wade. And it comes from all sides. My prosecutor friends are horrified.
Wow.
If there is a strike, if there is a works, I won't be surprised. Can you imagine showing up to some of these offices and be like, yeah, and that guy made $700,000 and then got clowned by a Wayans brother on the Daily Show. Really? That's how we spend millions of dollars? Remember, that case is stolen. Prior to this, one of the most respected judges in Fulton County and the big courtroom and an enormous millions upon millions upon millions. And this is the kind of guy that's getting paid, and you're a prosecutor making 80, 100, 110, working 100 hours a week, saving lives, dealing with rape victims, dealing with murder victims, dealing with the kid. And you got this guy who, after he got kicked off of a case for something, everybody's kind of like, yeah, it's good he's gone. Then continues to flog that brief thing. Dude, what are you thinking? If Fani wasn't done with him before, she should be now.
Yeah.
So, guys, this was awesome, and the hour went.
This was fun.
Hour went fast.
Really fast. I just looked up and was like, "Oh my gosh, yes!"
We're at an hour.
Fast.
We are. Yeah,
we're going to schedule another one of these, and I promise I will let Scott speak. But Scott today played Jack, and I had to put him in.
That's perfectly fine.
Jack.
No, it's always good having you here, and I just kind of let you go, Josh, because you have so much knowledge, and that's why you're here.
I think that, and I love the forum. I love the platform. You know, I'm one of your biggest fans and biggest supporters.
Thank you.
I'm always going to be there. My friends are always going to be there for you because you do legitimate citizen journalism. You do a legitimate show that lets people talk and put stuff. So this is the kind of stuff we need more of. We need a little bit less of. Everybody knows what I'm talking about.
Yeah, we get it. We get it.
We get it. Yep. Now, thank you for that, Josh. We really appreciate you saying that.
And go love your families, people, and go. I'm going to close with this. Worrying about the what happened in the past is depression. Worrying about the future, that's anxiety. Don't worry about either of them. Live right now. Enjoy the ones you're with. Make the memories. Do something fun. Pay attention to interesting things.
Great advice.
That's what I'm really trying to do.
Yeah.
Great advice.
Very good point.
While you're at it, like this video and subscribe so you can see more of Josh in the future and 100%. Some other good stuff too.
We'll definitely have you on again.
I look forward to it. Thank you all so much and have a great week.
Thanks, Josh.
You too. Take
care.
As
well. Take care, Josh.
Bye, everybody. Thank you.
Bye, guys. Thank you for being here.